Good morning to everybody. This short lecture, or better reflection, will be dedicated to one of the central notion in the theory of legal interpretation, which is the notion of interpretive correctness. We are used to talk about right answers, right interpretations, correct or incorrect interpretations. However, when we use this kind of words, it is not always clear what we do have in mind, what we do refer to when we use these words. So the purpose of this very short talk is to cast some light on these notions. So, first of all, I think that when we think about the idea of a right interpretive answer or a correct interpretive answer, we may distinguish at least 6 different meanings. First, a meaning which has to do with ontological correctness. Secondly, a meaning which has to do with methodological correctness. Third, another meaning concerns ideological correctness. And then we find a meaning dealing with jurisprudential or case law correctness, doctrinal correctness, and finally, cultural correctness. Let's start by the notion of ontological correctness. When a certain interpretation is right, is correct in an ontological sense? Well, we may define this notion as follows: that a certain interpretation is ontologically correct if and only if that interpretation is suggested, provided for, set forth for the legal provision at stake by the law itself, from the law in itself, by das Recht an sich, we may say, using a German expression. So, I call this first notion ontological because the idea is that in this case the interpretation is provided by the law, and so is an objective interpretation of a legal text, not something depending on subjective attitudes, preferences, beliefs of the interpreter. The second notion is methodological correctness. In this case, we may say that an interpretation is methodologically correct if and only if that interpretation can be identified by an interpreter by using the translation rules which are available in a certain legal culture at a certain time. By translation rules, I mean those rules which provide interpreters with as many instructions on how to translate a legal provision, say an article of a constitution, into some explicit norm. Consider, for instance, the translation rule of original linguistic meaning. This rule somehow claims that you should translate constitutional provisions into the explicit norms which correspond to the linguistic conventions at the time in which the constitutional provision was enacted. So, methodological correctness is a matter of correctness according to the set of translation rules which, as a matter of fact, should be used by any interpreter in the legal culture. So, in a sense, methodological correctness depends on certain inquiries which are sociological inquiries, because we must first identify the several translation rules which are available in a legal culture, and then use these different rules on the same legal provision and see what interpretive outputs we'll get. The third notion, ideological correctness, has can be defined as follows. An interpretation of a legal provision is ideologically correct if and only if it is the ontologically correct interpretation from the standpoint of a certain ideology of law present in the legal culture. Here, notice, the idea is that we have ideologies in a legal culture. That means comprehensive visions about the law, about the proper way of interpreting it, about the proper role of judges and legislators in it. So an ideology is a normative point of view which affects the activity of interpretation. Now, this idea of ideological correctness, ideologically right answers, right interpretive answers, precisely pretends to capture this idea that every interpreter, if she is seriously taking her job, usually bring to the operation of interpretation her own comprehensive vision about the law. And this comprehensive vision about the law is what affects the choice of translation rules and what affects the choice of interpretive resources. That means the data in the basis of which the legal provisions get translated through translation rules into as many expressive rules, expressive norms. A third notion is case law or judicial correctness. A certain interpretation is judicially correct if and only if it is the ontologically correct interpretation of a certain provision from the standpoint of some judge in some judicial opinion. Notice here, the idea is that we take the standpoint of judges and we see the law and correct interpretation through their eyes. And in this case, it is sufficient that a certain interpretation be proposed by a certain judge inside of a certain opinion for that interpretation to be possible to be called a judicially correct interpretation. Of course, we can distinguish here between a weak and a strong sense of judicially correct interpretation. In a weak sense, it is sufficient that just one judge present a certain interpretation as ontologically correct inside of an opinion, while in a strong sense, it is when that certain interpretation is presented as correct by the majority of judges in the legal culture, by the most important authoritative judges in it. Doctrinal correctness follows, in a sense, into the same steps of case law or judicial correctness. In this case, a legal interpretation is doctrinally correct if and only if it is ontologically correct from the standpoint of some jurist. Again, we can distinguish here, like for judicial correctness, between a weak and a strong sense of doctrinal interpretive correctness. An interpretation is doctrinally correct in a weak sense if at least one jurist in one doctrinal essay proposes this interpretation as ontologically correct. On the contrary, it is doctrinally correct in a strong sense whenever the majority of jurists working in that legal culture endorse that interpretation and propose it as ontologically correct. And finally, we have a notion of cultural correctness. This notion somehow crosses the idea of case law and doctrinal correctness. An interpretation is culturally correct if and only if it is ontologically correct at the same time from the standpoint of some judges and some jurists. Again, we may talk of cultural correctness in a weak sense. That means that it is sufficient that this interpretation is considered, proposed, set forth as ontologically correct by at least one judge and one jurist. Contrariwise, it is culturally correct in a strong sense when the majority of judges and majority of jurists at the same time share the idea of considering and presenting and defending a certain interpretation as ontologically correct. So we have these 6 different notions of interpretive correctness. Let me just say a few words to conclude my short talk. There is a clear difference between the notion of ontological correctness and the other 5 notions. The other 5 notions are, in a sense, descriptive notions of correctness, of interpretive correctness. They are descriptive because a sentence affirming that, for instance, interpretation I is methodologically correct from the standpoint of translation rules R1, Rn, is true or false according to whether this interpretation can or cannot be identified by using those translation rules which, as you remember, belong to the legal culture at stake. Likewise, when we make a statement of ideological correctness, we claim that a certain interpretation is ontologically correct from the standpoint of a certain ideology of law which is present in the legal culture. So this statement is true if there is an ideology in the legal culture which is such and such in such a way that that meaning is the ontologically correct meaning of a legal provision at stake. And it is false in the contrary case. And the same applies for the other notions. So the notion from 2 to 6 are descriptive notions. But what about the notion of ontological correctness? The ontological correctness, as you remember, claims that an interpretation is ontologically correct if and only if it is the meaning that for a certain legal provision the law itself provides. Now, which is the condition of truth of such a statement? Well, it is clearly that there is something which is the law itself, the law in itself, and this entity provides an interpretation for a certain legal provision. Unfortunately, such an entity does not exist. We have legal materials. We have legal materials like constitutions, statutes, regulations, which get used and interpreted by judges and juries. But we don't have anything like the law in itself, which provides interpretation for its own norm formulations. So the idea of ontological correctness is the idea which makes us think at the fact that there is no objective interpretation of legal provisions if by objective interpretation we mean an interpretation which is provided directly by the law, notwithstanding the preferences, attitudes of interpreters. No, the problem is this one. Any legal provisions must be interpreted by some jurist, judge, lawyer, or even common person. Without this kind of operation, there is no meaning legally relevant to be connected to the legal provision itself. Accordingly, all ideas of a right answer, of a right interpretive operation, of a right interpretation, is always some claim about ideological, case law, doctrinal or cultural correctness. Thank you for your attention.